Hello and good morning, everyone. My name is Jillian Bender Cormier. I'm with Bender Insurance Solutions. We want to welcome you to our last Bender U of the year, 2024 Labor Law Update. What is California up to now? Some housekeeping notes. If you have any questions during the webinar, please feel free to type them into the chat box or in the Q&A section. We'd like this to be an interactive experience, so our presenter will be available to answer your questions in real time throughout the webinar. During our additional Q&A time at the end of the presentation, I'll be sharing other questions you might have with our speaker. We want to be conscious of time, so if we don't get to answer all of your questions, we'll gladly reach out to you individually after the webinar. You are all in listen-only mode and will remain muted throughout today's session. This session is being recorded. At the conclusion of the webinar, the recording link as well as a copy of the slide deck will be forwarded to you. We have an incredible expert sharing with us this morning, but I'll let our own Vice President of Alternative Risk, Roland Gillen, have the honor of introducing him. Welcome, Roland.
Thank you, Jillian, and good morning, everybody. It's my pleasure to introduce Derek Decker with Krogan Decker. Along with his business partner, Sean, they have a law firm that truly takes care of their clients in providing top-notch legal service. Derek's practice is civil litigation, transactional work, and providing day-to-day legal advice to all types of businesses in the Sacramento region, and many of them are my clients. Earlier this year, if you attended the PAGA webinar, you had the opportunity to listen to Derek and provide a compelling update on PAGA. I know he's going to spend a little time on that again, and it's my pleasure to welcome Derek. Thank you, Derek.
Thank you, Roland. Welcome, everybody. A good morning to everybody. It sounds like I hear from Jillian and Roland, it was a really good turnout for today. It's California. Employment laws are always an issue, and 2024, the bills that are becoming law, starting most of them for January 1st, 2024, make some pretty big changes, things that employers should certainly be aware of. And I hope we have enough time today to go over any questions any of you have. Some of these new laws certainly call up other issues. And like Jillian said, if anybody has any questions as we go along, feel free to raise them. Some of this stuff, we can certainly get into it in more detail. So, can everybody hear me okay? I wanted to check first.
You sound great.
Sound good? Okay, thank you, Jillian. All right, a little background on the laws that are coming into effect in January of next year. We're at the end of COVID-19, certainly as to the state declaring it to being an emergency. That ended February 28th of 2023. We do have some laws pertaining to COVID, though, as well, that are going to be coming into effect. The economy, generally a bearish stock market, certainly inflation, higher interest rates. From what I know, reduced state budget overall. Potential job shortages, although it can certainly depend on the industry. We have some labor strikes. It was a year, 2023, where more than 80 employment bills were signed. That's fairly high for California. 26 of them were vetoed, or 26 bills were vetoed. The bills that we're talking about, and when I say a bill, that is to the extent that that is passed and has been signed off, that is now a law. For the most part, these bills are going to become something that is a statute, that is a labor code. Some of them may be a little different, but the ones we're talking about are going to be effective January 1st, 2024. Some of them may be a little bit later, and I will note that as we go through the presentation. So the first one is TRO and protective order laws as it pertains to the employment, as it pertains to the workplace. By TRO, I mean, of course, temporary restraining order and protective orders. So SB 428, and when it says SB, you can look, I believe, all of these bills up. And again, right now they're not always put exactly into a statute. So if you want to look up the details of any of them, you can just Google SB 428. Stands for Senate Bill 428. There may be some ABs we talk about, which are assembly bills. So SB 428, this one's effective January 1st, 2024. What it does essentially is it takes the domestic violence and civil harassment restraining order statutes and procedures and hearings, largely how those work. There are some differences and nuances, but it makes those applicable to a workplace. And in this case, it authorizes, in the correct situation, an employer who has an employee that has suffered harassment. The employer can seek a temporary restraining order and an injunction on behalf of the other employee, on behalf of the employee, but most importantly, on behalf of other employees. So primarily, this would apply to a situation where an employee may be undergoing harassment. It could be harassment at the hands of or from another employee. It may be from a third party. It may be from a family member. It could be all sorts of different people. But if that is spilling over into a situation where other employees are being impacted by it, this will allow, in a proper situation, an employer to seek a restraining order. And in California, generally, and this is a very brief primer on restraining orders in general, courts are going to grant them, or more inclined to grant them, if there's violence, if there's threats of violence. Those things are paramount for any restraining order judge. There can also be what is great and irreparable harm from a course of conduct from harassment. That's something where it may not rise to the level of violence or actual violence or threats of violence, but it is something that is ongoing, it is substantial, it is, to an objective, reasonable person, causing somebody significant emotional distress. And that can be subject to dispute, but I think, at least for the clients we have, we did see a bit of an uptick in, I would say, tension and turmoil between employees to some degree in certain industries. And so I think this is the legislature's attempt to address those issues. The next one, and there's a couple bills becoming law on this issue, cannabis use. So SB 700. This is a job application law that is going to apply. It's going to make it unlawful for an employer to request any information from an applicant for employment relating to their prior use of cannabis. It will prohibit employers from using information obtained from a criminal history about that applicant's prior cannabis use unless you're permitted to do that and look into it under the state's Fair Chance Act or state or federal law. So Fair Chance Act applies to background searches and use of criminal histories on applicants. That's going to be the primary law that would address this issue. But you can get detailed, and you can get into a lot of nuances with what you can look into for prior cannabis use. But in general, if you have a job application that's asking about prior use of cannabis, it's not going to be permitted. There may be certain exceptions to it depending on the industry. And also, if there's a cannabis use issue that pops up in a criminal history, you're going to need to make sure that there are grounds to use it if that's something that the company is going to rely on. This is another bill becoming law also pertaining to cannabis use. It's Assembly Bill 2188, which is going to make it unlawful for an employer to discriminate against an applicant or an employee for use of marijuana off the job and away from the workplace. And this gets a little nuanced in terms of how drug testing works, but it is also going to make it unlawful to require drug screening tests that finds that the person and take adverse action on it if the person has non-psychoactive cannabis metabolites in their system. So what that means is, I'm not a drug testing expert, but you cannot rely upon a drug test that shows non-psychoactive metabolites, meaning they may have used cannabis, but it's no longer a situation where the drug testing is finding psychoactive metabolites in their system that would indicate in most situations, some kind of impairment or being under the influence.
Hey, Derek, quick question.
Yeah.
Is it January 2025 or 2024 for SB 428?
For the last one, 2188, that one is January 1st, 2024, next year.
Oh, okay. And what about SB 428?
We had SB for the cannabis. We had SB 700, and then we had 2188, and both of them. Yeah. Yep.
Got it.
Yeah, that should be January
Wonderful.
1st. Yeah. So, quick, question that we get a lot with this is, there's these limitations on cannabis, right? It's important to note that neither of these bills that are going to become law prevents an employer from taking action based on, somebody coming into work under the influence of cannabis. It doesn't allow people to transfer, give, distribute, sell, possess, or any of those things, cannabis at work, regardless of whether or not, and this is a broader discussion, but regardless of whether or not they have, a medical marijuana card or anything like that. That is still something that absolutely can be prohibited. What I would say, and we can go into this in more detail as well too, just to know, there's two different tests for an employer for when you are testing for cannabis or any other drug. There's a standard that applies when people apply for the job before they actually become an employee. That is generally easier to require drug testing across the board. It is a much more difficult thing to do in California, depending on the industry. If you've got a really safety sensitive industry, if you have truck drivers, something like that, that's going to be a different situation. But once somebody becomes an employee, it becomes more difficult to do drug testing of any kind, even if it's across the board. And in fact, once you have already hired employees, doing just across the board drug testing, unless there's a very specific need for it, is usually a tricky and unlawful area. California courts look at drug testing as a search of the person that involves privacy rights. So in California, in order to test somebody, you have to have a reasonable suspicion that they are under the influence or, distributing, possessing, or selling cannabis. And that can be a tricky thing. Normally people are not going to say that they are using something, and you might hear from somebody that they believe somebody's under the influence. What I would say on this is reasonable suspicion testing is very fact intensive. It is keeping track of everything that would indicate to a reasonable objective person that this person is under the influence. So not having an assumption or a suspicion or something like that. It is an issue of observing and assessing whether or not a reasonable person, knowing all of the facts of what's going on with this person, would believe that there's a quote unquote reasonable suspicion that they're under the influence. If that standard is met, an employer can drug test an employee. The next law is Senate Bill 497. This is protected employee conduct. This is a very important statute, very important legal principle. It is something that a lot of employers have gotten into trouble with because it pertains to the issue of a retaliation claim. So what this specific statute does, it amends two different labor codes to create a rebuttable presumption in favor of an employee's claim if the employer discharged, retaliated against, or engaged in any other essentially adverse action against the employee within 90 days of that employee engaging in protected activity. So I'll go through that just briefly again because it's important. So a rebuttable presumption is something that a court, a judge, a jury would have to assume is true unless there's sufficient evidence against it. So it's an inference, it's a presumption that the employer did something wrong, that there was retaliation by the employer if certain things happen within 90 days of, for example, an employee termination. The labor code that this statute refers to is Labor Code 98.6. The protected conduct is if an employee has filed a labor code claim, if they've threatened to file a labor code claim, if they are testifying in a labor code proceeding, or, and this is why I put this in bold at the bottom, is this is important, if they've complained verbally or in writing about any rights under the labor code. So that's really important. What that means is if an employee, given this new law, if an employee comes, let's say you have a large company, they don't even come to the HR person, they come to an assistant manager, right, who may not always deal with HR issues, and they complain about something to do with their paycheck. If there's a termination of that employee or a demotion, a suspension, a reduction in pay, within 90 days, the law is going to immediately presume, again, it can be rebutted, but it's going to immediately presume that the employer engaged in unlawful retaliation. And that is a pretty significant thing. Now, in many cases, there's a way to, to rebut that presumption if, the person has done something egregious. But, not all employment situations are that clear cut. And again, why I put this in bold and just flagged it for people is that's all it takes. It doesn't even take, a written complaint. It just takes a verbal complaint to raise this presumption. And so what I would say about that, the penalties for this, in addition to a legal proceeding, are up to a $10,000 penalty per employee. There's additional damages that can be recovered because this type of a situation, if it exists, could also support a wrongful termination lawsuit. Retaliation lawsuits in general, I would say, they catch employers unaware more than a wrongful termination does, simply because that concept of, well, we took a certain action that we believe was justified and in good faith, but because you did something prior to that, there is now, in certain situations, a presumption of retaliation. So that is something to really be aware of. Those types of lawsuits can be easier to prove for an employee than a wrongful termination lawsuit. What that law means is personnel files and employee issues need to be well documented. There's no reason not to have reasoning for someone's termination unless you've talked to an HR specialist or an attorney and they tell you, hey, there's something that we just don't want to put in writing. But certainly if there's a course of conduct that led to somebody being terminated, that should be documented so that you can go back if needed and rebut this presumption. Managers need to be trained in HR and how to address these issues. Some kind of at least basic human resources and labor code training. The reason I say that again is if you have a large company or if you have a small company, if that complaint is made to somebody with any kind of management authority, it's going to be considered as being given to the entire company, and it's going to raise that presumption. So everybody needs to be aware of these issues and take any kind of complaints, even if there can be plenty of complaints that are not good faith. There are plenty of complaints that don't go anywhere, but they should all be treated as something that needs to be addressed and looked into. Anything dealing with pay or time or labor code issues. I would also say that a review generally needs to be done before people are terminated or laid off. One of the big things that we talk to clients about is, has this person made prior complaints? Because if they have, that usually opens up a discussion into, what were the complaints? And from my perspective, our office needs to make sure that those were investigated. If complaints have been made and they've been investigated and there's nothing to it and it's been documented, I have no issue saying go forward with a termination. And in most cases, that is what happens. And I also wanted to put this for people. I love this book. It's a really good book for any company, for HR, for management. It's the Cal Chambers Labor Law Digest. You can get it at store.calchamber.com. It is the right amount of a book for business owners, with enough legal citation and tips put into it that I think it's extremely helpful. I know a lot of lawyers use it. So I would say if you have HR, get that book. SHRM, Society for Human Resources Management, is also a good resource. Obviously, everything Bender does, all the presentations they do and updating everybody, you really need to be on top of this stuff. Every company does in California. So thank you to Bender, I would say, as well, for keeping people informed on this stuff. You have to in California. Few other things, good resources. It's a good idea, especially if you have a larger company. If you have a company where their employee liability is a big issue, do some kind of HR labor code trainings. Our office does them. A lot of law firms do them. Have in-house counsel sometimes in the right company. That's obviously a big decision to get to, but there are some companies that it's a good idea, or at the least have some kind of connection with outside legal counsel that can function in that manner if you need them to. Certain companies will need, obviously, and I understand I'm getting into business advice. It's not my place to do that. I'm just saying from the perspective of what I see for clients. An HR director or manager, at some point, somebody at least, despite the size of the company, needs to be responsible for HR. And HR consulting companies are a great resource as well too. The next law is protecting survivors from weaponized defamation. This is AB 933. This is not something I don't think is going to become a common thing for employers, but just so people are aware, it makes certain types of complaints, statements, representations, communications entirely protected, which means people can't be sued for them. They are privileged communications, and one of those is communications made by anyone without malice regarding any incident of sexual assault, harassment, or discrimination. And so it means that people cannot be sued for making those types of communications unless they're made with malice. That's a different legal standard that requires some discussion, but the broader discussion with this is obviously all complaints, all communications regarding any kind of unlawful conduct at the workplace should be treated as absolutely seriously as possible. They should be investigated. The appropriate people should be listened to and interviewed as part of any investigation. But just so employers are aware, certain types of communications are going to be entirely protected under the law. We covered that. Well, the other part of it, I would say too, is, and I think everybody knows this, but workplace investigations of any kind should be kept entirely confidential. There are certain people within a company that will need to know what's going on. Managers generally are going to need to know for most investigations, depends on the type, unless there's a strong exception why. All those investigations, interviews, everything should be kept completely confidential unless there's an exception to it. AB 11228 is going to be a law that applies specifically to fast food restaurant industry. So if anybody listening is in the fast food industry, you've probably already heard about this. It's been a big topic in the industry. This law is going to create a fast food council, and that council is going to have the authority to create regulations, which are laws, under the Administrative Procedures Act. So how this is going to shake out and what it's going to, what the council is going to do in the future, we don't know yet. But the council that is being created has been empowered to establish an hourly minimum wage for employees, increase the hourly minimum wage pursuant to specified parameters, what year it is, that kind of thing. And this is a fairly broad grant of authority, set forth requirements, limitations, and procedures for adopting and reviewing fast food restaurant health, safety, and employment standards. So that again is a broad standard. What exactly the council comes up with and how that it needs to be implemented, we will have to see. But it is it's certainly an important event within the fast food industry. Something to keep an eye on. SB 616 is paid sick leave, and sick leave can get a little bit complicated sometimes, but the highlights of the new paid sick leave laws are it is going to expand the number of sick days under the Healthy Workplace Families Act of 2014. That was the law that provided for paid sick leave. It's going to expand it from 3 to 5 days. So employees now get 40 hours. Again, this is going to be starting January 1st, 2024. It is going to also increase the accrual threshold for paid sick leave from 48 to 80 hours that can be accrued. And we will get a little bit into the difference of accrual versus front loading. It's going to increase the employer's authorized limitation on the use of carryover sick leave. So this is when sick leave gets carried over from year to year to 40 hours in each year, and redefines full amount of leave to mean 5 days or 40 hours. This new law does not invalidate a front-loaded sick leave policy. And so I think people that are listening probably know this. There's two ways to address sick leave and provide sick leave. One is an accrual method, meaning employees accrue it based upon a certain rate, based on the number of hours that they work. And what that requires, obviously, is keeping track of accrual and doing a certain amount of bookkeeping with it. The other option is doing a front-loaded policy, which would be providing all of the days up front. The moment somebody starts employment, they get, it used to be the 3 days, it would now be the 5 days. So this is important. This law does not invalidate a front-loaded policy, and front-loaded policies don't require carryover from year to year. So that's the benefit, I would say, of a front-loaded policy also obviously is less bookkeeping to some degree. The disadvantage would be, people are getting the entire lump sum of sick leave up front. So
Hey,
obviously,
Derek, a couple questions have come in.
Yeah.
Can we still request 90-day waiting period before they can use the paid sick leave?
Yeah, that is still something that is under the law. Yep.
Wonderful. We had two questions with the same question, so thank you.
Yeah. It's anybody that's dealt with sick leave knows that there's a lot to it. There really is. The other thing I would say on it, the last note on the slide is be aware of local city or county ordinances that provide greater benefits. We had a client recently dealing with Oakland, and Oakland does things different. And you got to be aware of that if you have, even if your company isn't based out of one of those cities or counties, but you even have a site or a store or a location in that city or county, for the most part, depending on the ordinance, those laws are going to apply as well.
And we did have a couple other questions that came through. If you front load sick time, you do not have to provide a carryover or cap at 80 hours. I guess that's more of a statement. Is that correct?
Yeah, that is correct. That is the benefit between an accrual and a carryover. The accrual, you're going to have to do the carryover, and with a front loader, you don't. Yeah. And I
Wonderful.
think the logical theory, I think, behind it is if you're getting everything up front at the start of the year, well, you shouldn't be able to carry it over at the end. Whereas if you're only accruing it, and you only get the full amount 3/4 of the way through the year or whatever it might be, you should be allowed to carry it over rather than it all going away. So I think that's the idea.
We did have one other. We front load with a 90-day waiting period. Does the 40 hours have to appear on the pay stub on day 1 or after day 90?
I would put it on. Yeah, it's a good question. It's a good nuance. Like a lot of people probably know, you're supposed to have your sick leave accurate sick leave balances. And if you have a PTO policy that substitute for sick leave, this should also be on the pay stub, but sick leave balances should be on pay stubs. It's actually a labor code violation if they're not. So the balances should be on there. If the policy provides for the front loading, I would put the sick leave on the pay stub, because that is what the balance is. That's what they have. That's what it should show. That's what's accurate. That doesn't mean that you cannot tell people if they want to use it, and this should be in something in writing. It should be in a handbook or some kind of written policy. It should be very clear, though, that they can't use it
until the 90 days is up. And you know, HR may need to field the question of, well, why do I have 5 days but I can't use it? Well, you know, in the employee handbook, you know, we have a waiting period, and that is lawful.
Okay. And we do have two last questions I'll ask before we can carry on. There is still a cap of 40 hours that can be used in 1 year, correct? And to follow up that, also, if you offer vacation hours, do you also have to offer sick hours?
So the accrual, to answer the first question, the accrual has gone to 80 hours now. So if it's being accrued, the accrual is 80 hours. If it's a front loaded and they're provided with 40 hours up front, I'm sorry, tell me I know there was two questions there. I want to make sure I get the second one as well. Sorry, Jillian.
Yes. So it said also, if you offer vacation hours, do you also have to offer sick hours?
Yeah, you don't, and this is maybe maybe it's a linguistic issue, but if you're gonna have a policy where you have some kind of paid leave and you want it to substitute for sick, make it a PTO policy, make it a paid time off policy. Not that I don't want to say that the statutes expressly say if you call it vacation, it's not applicable, but it's just a lot easier to prove to a court. You can have a policy where the company provides a certain amount of paid time off. Again, if you're intending for vacation to substitute for sick because the vacations the company provides are greater than and cover everything that sick leave requires, right? Like we give people 15 days off a year with a paid time off policy. We're calling it vacation. I would call it PTO. I would call it paid time off, just because any of the interpretations that I've seen have looked at it from the perspective of having a PTO policy that covers everything that's required of sick. So long story short, yeah, if you have a PTO policy and you're already providing paid time off and it gives all of these benefits, you do not have to have also a sick leave policy. Yeah. Now the one small caveat, and it doesn't come into my mind right now, but I would still check local ordinances. I would still check local ordinances on that. But for state law, no, you can have the PTO policy substitute and cover everything that sick leave does.
Thanks, Derek. And then the last question that I had was, and it sounds like this person's in healthcare. A department, they have 12 hours per shift. Will they have 5 days equals 60 hours?
So they're in healthcare in a department, and they have 12-hour long shifts.
Mm-hmm. Mm-hmm.
And
it says, if they have 5 days, will that equal 60 hours? I'm guessing that means for the paid time off, or the paid sick leave rather.
Yeah. I would say if there's an issue about the amount of sick leave that an employee is getting, look at it in terms of hours, right? Look at it in terms of hours. If the work days are divided up in a way where it's not your typical 8-hour day, it's the hours, right? It's so instead of don't focus necessarily on the 5 days. It's that employees need to have 40 hours of sick leave. Either again through an accrual or a PTO method. So if you gave employees at that workplace 40 hours, you could do you'd have 3 full 12-hour shifts and an extra 4 hours essentially. I don't know if that answered it.
Yeah, and this is a hot topic, so I'll cut off the questions for now, but we will definitely have more Q&A time at the end, folks, to come back to these questions. But thank you so much.
Yeah, happy. This topic's it's a complicated one. Okay. So this is SB 553. This is the Workplace Violence Prevention Plan. This is an important one too, because it imposes a fair bit of requirements on a company. Yeah, so all employers now have to establish, implement, and maintain at all times in all work areas an effective workplace violence prevention plan containing specified information. Any kind of information relating to Workplace violence, a complaint of workplace violence, threats of it, incidents of it have to be recorded in a violence incident log. Employees have to be provided with effective training on the prevention plan. The statute on this doesn't go into, it goes into a certain amount of detail, but it doesn't go into exactly all the detail that goes into a plan. And what I would say, I think, part of the reason for that is every industry could be a little different. If you have people working at an internet marketing company and everybody works remotely, the requirements may be a little bit different than if you have, a large facility where everybody's there in person. But the key is it has to be effective. It has to be something that looks at what are the risks, what are the issues, and how does the company address these things if they're reported or if they are ongoing, if they're happening. Additional training has to be provided when a new or previously unrecognized workplace violence hazard has been identified, when changes are made to the plan. One of the things I didn't put in here that actually is part of it is employees have to be given an opportunity, and how this is applied and what it means hasn't been, addressed in detail yet, but employees have to be given input on this plan as well, right? And what I would say with that is, certainly to the extent company training is being done, it should be an interactive process. It should be something where people are providing input, asking questions on how the plan's going to work, and if they have concerns about it. This statute will also require records of violence hazard identification, evaluation, correction, training, the logs, and investigations to be maintained, and these records to be made available to the state, to employees and employee representatives on and after July 1st of 2024. So employers have a little bit of time to get this in place. My sense would be, and I think this is already happening, there's already third-party companies that are addressing this. Certainly HR consulting companies are addressing this. Law firms are addressing this and working on getting these types of plans and policies in place for employers, and working on the training as well for that. This is a workplace violence statute as well, SB 553. This is what we talked about earlier. It's also part of an additional statute, which is allowing an employer to seek a temporary restraining order to prevent unlawful violence or credible threats of violence. My only note on this is, I think people know this, but employers have a legal obligation. This isn't something new. Employers have a legal obligation to ensure the safety of their employees, and that means, from other employees, from customers, from vendors, from third parties. So this plan, certainly, I would say, from a liability perspective, the way you're really going to see this become an issue for some companies is if something does happen to an employee, some incident of violence, and the employer doesn't have this kind of a policy in place. They don't have the logs, they don't have the training. That's going to take what is already a bad situation and make it a lot worse.
Hey, Derek, a question on this. Do you anticipate that there will be a sample plan published like the COVID plan, or is this going to be on the employer to fully draft?
That's a good question. I'm trying to recall the statute in my mind right now and the history of it. I don't believe, and I could be wrong, I don't believe there's anything in the statute indicating expressly that the state is going to provide samples. I will say that I know, again, and there's probably multiple resources for this. Our office has done them for clients, but I know SHRM, Society for Human Resource Management, already has a sample policy. If you are a member of that, I would say for a lot of companies, and I don't mean to just constantly be giving resources, but for a lot of companies, if you're dealing with HR issues and they're ongoing, SHRM is a really good resource. They have really good information and policies, sample policies, things like that. So I know they already have one of these that's a sample policy. But again, I think some of this, the issue is it's going to depend to some degree on the employer. I don't know that you'd want to do just a template blanket policy unless the state actually endorses it, because it may vary a little bit. You know, the training from company to company is going to be a little bit different based on how it works and the industry.
Thank you. And one last question on that. Is training from a module or an online training for workplace violence, would that check the box for the training, the violence prevention training, or does it need to be something beyond that?
Yeah, another one of those issues where I'll say off the top of my head, I don't think the statute explains that. Again, I could be wrong. You know, these are detailed statutes. There's a lot of language to them. I don't believe it expressly endorses that. What I would say, however, is, you know, employers already have an obligation to do the sexual harassment training. The state has endorsed fully the idea of doing that online as a module. I have no reason to think that that wouldn't be effective. And in fact, in some situations, from a legal perspective, there may be some more benefits. I think an effective training is the most important thing. And if that requires sitting down with people, depending on the industry, right? Some industries have more robberies, more thefts, more issues. And so that may require something different. That being said, from an employer and a legal perspective, having the module available later to be able to show what the company did, that can be a benefit. You know, if it's a good module and it goes into everything in detail and you have proof that everyone's taken it, I don't see any reason right now, and I doubt the statute's going to be amended to make it prohibited. I don't see any reason why that couldn't be done. And in fact, in many situations, you've got evidence later.
Wonderful. Thank you so much.
Yep. SB 553, I'm just making sure I'm not going too slow. This is the COVID law that I referred to. This is an interesting one. So the long and short of it is, employers are going to have to offer to certain laid off employees any future job openings that they are qualified for. Not just that it's the same position they had when they were laid off, but that they're qualified for, right? And laid off employee is any employee that was employed for 6 months or more, and their separation from the company happened after March 4th, 2020. And this is the important part, was due to a reason related to the COVID pandemic, including public health directives, government shutdowns, lack of business, reduction in force, or other reasons, right? Here's where it gets a little more tricky. The law also creates a presumption that a separation from employment was due to a lack of business, reduction in force, or other economic non-disciplinary reason. It assumes that they were separated due to COVID-19, unless the company establishes otherwise by a preponderance of the evidence. So again, it's something where the law is implying something, presuming something, unless the employer is able to prove something different. So again, if what it means, you know, as an example would be somebody's laid off, business slowed down, but the business slowing down had nothing to do with COVID, right? The law is going to presume it was related to COVID unless the employer establishes otherwise. So it's a bit of a tricky requirement where companies, this is what I would say is, companies should make a list of employees that fall within this definition, right? And for some companies, this may be easy. You know, it may be, well, we laid off 10 people and we know it was due to business declining significantly. That might be a little bit more easy situation that, you know, the company knows that that's what the layoffs were due to. The trickier thing is going to be thinking, well, do other people, do they fit this definition, right? And I will say this, you know, there's also the question of, well, how are people going to know about this? You know, in reality, most employees are not going to necessarily know that they fall within this definition and there's some requirement to notify them. But some of them might. People know a lot from Google. People go on the internet and research all sorts of things nowadays. And so, you know, if people are not notified of something that is a job opening that they're qualified for and it's not provided to them, technically it could support a wrongful failure failure to hire claim. I don't want to put too much emphasis on this being a real issue, but it is something that companies need to look at. Certainly if it's a situation where you have a lot of employees where it's clear that they fall in this definition. Non-compete agreements. This law, so what I would say in general is this, non-compete agreements, some kind of a written agreement that an employer says, you know, you can't compete with me while you're working for me or after, sometimes is what you see. Those have been, for the most part in California, due to case law, those have been invalid for some time. They're very, very difficult to be upheld unless there's some specified exceptions. What this law has done, though, now has expressly made those types of contracts or agreements unlawful, and has provided for civil claims, damages, attorney's fees if employers have people sign them. So if your company is having people sign something that in any way prevents them from competing, I will say this, you can't, it's okay to have people not compete while they're working for your company. I still wouldn't put it in a written agreement now because of this law, but certainly as to going forward after they leave the company, shouldn't have people signing non-compete agreements. This law avoids the application of any of those agreements, no matter how narrowly tailored, no matter how specific it is, can't have them, they're invalid. Again, existing law already dealt with this. One thing I would say as well, watch out for non-solicitation agreements. That's a little bit of a different thing where, you know, employees can't come and poach other employees after they leave. Depending on what those say, those can be an issue now as well too. We have a lot of clients ask this though, you know, I have something valuable about my company. I have things that, you know, it may be a list of very valuable clients and the connections and, you know, their payment histories and all of that. This law does not invalidate trade secret protection, you know, and so a company can still protect its trade secrets. That is a different issue from a blanket non-compete. You know, there's more that you need to show for a trade secret. You got to show that it is a secret, that it is something of value, that it's been built up. That is a fairly complicated topic. I won't go into it, but just to know that if a company has trade secrets, those can still be protected. But those need to be protected in a different way, so that they have their own nuances to how trade secrets need to be protected. This is a relatively niche law. This is venture capital reporting. The state is going to require venture capital companies to report to the state civil rights department at certain demographics for their funding determinations. You know, they're going to want to know certain things about the companies or the organizations or the endeavors that have been funded. Fairly niche as well too. This is a human trafficking law. It creates a civil right of action where a plaintiff can seek a finding from a court that certain debts were incurred as a result of human trafficking and without the consent of the plaintiff. Courts are empowered to grant any relief available under civil rights laws. I don't think this is likely for most industries to ever be an issue, but it is something that is that has been put in as a new employment law. Whoops, go back to that one. Fast food restaurant industry. We dealt with this one. This is actually the implementing statute that's going to give the authority for the Fast Food Council to do these things under the Administrative Procedures Act. These are the regulations we discussed about that are, again, pretty broad and sweeping. Leave for reproductive loss. The language of this law follows things you see for like bereavement loss. What this means is employees can take protected leave for up to 5 days for reproductive loss leave. This is failed adoptions, failed surrogacy, miscarriage, stillbirth, or an unsuccessful adopted reproduction. Only applies if you have 5 or more employees. It does apply to states, cities, and counties. There's certain limitations on it. There's a maximum of 20 days leave in a year. This is important. This is a whole very complicated topic. California Family Rights Act, and Fair Employment and Housing. So these leave rights are in addition to rights that employees might get under the California Family Rights Act. So there may be certain crossover between those where additional leave might be required. Has to be taken within 3 months of the event. You can require people, you can't require people. People can choose to use paid leave if they have it for this, otherwise it's unpaid. I put this in there. It's something that sometimes comes up for employers, either as bringing a small claims action or defending one. The jurisdiction for small claims has gone up. The cap has gone to 12,500. There's also another type of proceeding, in case people aren't aware, called a limited civil case. It's somewhere in between a small claims case and what I would call a regular Superior Court action. It's a more simplified procedure, and that's got up to 35,000. So there's different procedures to handle things other than a regular Superior Court lawsuit. Obviously, with each of these, it's going to be a quicker procedure, I would say.
Derek, one quick question for the previous slide before. Would this fall under the 12 weeks CFRA leave?
And you're talking about the reproductive loss?
Yes.
Yeah, it could. It certainly could. There's multiple categories under CFRA, right? If somebody has a serious health condition, if they're taking care of a family member, for example, with a serious health condition, yes, that's why I put this in there. Yeah, you could have a situation where certainly somebody has suffered a reproductive loss and they also have a serious health condition associated with it, and absolutely both of those leave rights would apply, and it's in addition to.
Thank you.
Minimum wage, I think everyone knows, gone up to $16 an hour effective January 1st. The important thing on that is if the company is classifying certain employees as exempt, many of those exemptions have a salary test. It may need to be twice what minimum wage is. So just keep in mind that if the company has people classified as exempt, it'll need to check the calculations on those exemptions to make sure that people are still being paid whatever they need to in relation to minimum wage. Otherwise, those exemptions won't apply. I think we're good here. So this is not new laws, not bills, but I wanted to just briefly discuss the 2024 trends. Wage and hour actions, from what our office sees and from what I hear from most attorneys, continue to increase. In terms of the universe of employment claims, they seem to be more favored at this point over discrimination, retaliation, wrongful termination claims. Not that a company cannot face those, certainly they can. But in terms of, there's certainly trends of what a plaintiff's attorney want to take because they think it's advantageous for their practice. And wage and hour claims are very much a focus right now. I don't see that going away. PAGA actions, which is Private Attorney General Act. If people aren't aware what those are, they are akin to a class action type of lawsuit where one employee who has suffered a labor code violation can sue essentially on behalf of the state and on behalf of the state to recover penalties for every other employee that has suffered a labor code violation. So it's a group action, it's a representative action that involves the rights to seek penalties for potentially many employees. They're particularly threatening. We did a presentation, Bender did a presentation on this previously. The most recent update on it is in California. There was a decision in California Supreme Court, the Adolph decision, that I don't want to say reversed, but really undid a lot of what the U.S. Supreme Court did, where the U.S. Supreme Court had allowed employers to compel arbitration of these types of action, basically break these actions up and make them go to an individual arbitration each, which makes it a much different type of proceeding. California Supreme Court has come back and said no, even if those grounds are met, the state basically is the party that is bringing this action, and those actions can continue. So the takeaway from all of that is, I tell all of our clients this: make sure your pay and time procedures and documentation are perfect. Audit how that's being done if you haven't. Make sure that the records, the calculations are beyond reproach. What you want for a wage and hour action, the first thing you want is great records, right? You want to be able to show that meal periods were taken and it can be proven. You want to be able to show that rest breaks were taken as much as possible, right? And I'm not, for most companies, suggesting that people clock in and out for 10 minutes, but you want some kind of a system that is consented to by employees. You want to make sure calculations are being done correctly. You want to make sure pay stubs have everything they need to on them. There's a lot of different ways that you can find a labor code violation, and POG actions, that's the only thing they rely on. And if you have violations and you have a lot of employees and it starts to recur, it starts to become an issue. And you made it to the end, and I will go to, if anyone else has any other questions. I think we did that.
Thank you so much.
Pretty good for time. Thank you. A little under the.
Well, we do have some additional questions that we didn't get a chance to answer, but again, folks, please utilize the Q&A section, the questions segment of the control panel to type in your questions for Derek. One of the questions that came in was, does sick leave have to be separate from a PTO type policy?
It doesn't have to be. Some of this is similar to what we discussed earlier. It does not have to be separate. You can have a PTO policy that covers sick leave. And in most situations, depends on the company, but for the most part, I would likely recommend that is what happens, right? It just makes it simpler. Some of the issues we see with employers is, it isn't necessarily that they're trying to do something wrong. It's that just the requirements of complying with things, or the record keeping and all that, becomes so much that just some innocent mistake gets made. So I would say with sick leave and PTO, in most cases, it's going to make sense if your PTO policy covers everything that sick leave requires, just make it a PTO policy. It's easier.
Thank you. And what would those policies look like for seasonal employees?
For a seasonal employee, well, I mean, the one issue with PTO is, to some degree, and I'll separate sick leave just for a little bit right now. PTO is an issue. You don't have to offer PTO, right? There's no requirement of offering vacation or PTO. To some degree, it's an issue of, what do you need to do in the industry to be competitive, right? What does the company want to provide as a benefit to attract and keep employees? So there's that issue. But to the extent PTO is going to be combined with sick leave, so that those requirements for sick leave are taken care of. For a seasonal employee, I think it's something where you might want to talk to counsel just to kind of address what it is. So I'm going to assume with a sick leave, with seasonal employees, they're not working there obviously all year long. So you may not want a front-loaded policy. If people are only working for 3 or 4 months, you're probably going to want an accrual policy in that case. What I would say is the accrual method is what it is under the statutes. So you've got to make sure that everything is being met with that. But you could have a policy that is simply a PTO policy for seasonal employees, that as long as it meets the accrual standards and they're getting the amount of sick leave benefits they need to, you could just do it that way. Although, again, I know I'm giving a lot of detail or thinking about this a lot. It really depends on the employer. It's a discussion with the employer, but it depends on the season. If it's a very short season and it depends on the position, it might be something where you just want a sick leave policy. You might not want to have that extra requirement of PTO as well.
Thanks, Derek. A question regarding workplace violence. the violence prevention training. What if there was an incident 2 years ago? Do we need to add this to the log, or does this start on January 1st, 2024?
No, you don't have to add it to the log. I would say when you look at training and what the plan is, certainly if it was a significant event, I would certainly assess that and, look at that in terms of making sure it doesn't happen again. What did the company do in response to it? What did the company learn from it? All of those things. I think it certainly goes to the plan and the training, but it does not have to go into a log. No.
Thank you. This is regarding the healthcare industry. What about the new minimum wage of either $18, $21, or $23 per hour will apply to healthcare employees, depending on the type of hospital or healthcare facility that they are employed?
Yeah, the minimum wage is different for the healthcare. I don't know, honestly, off the top of my head. I'd have to look at the statute just to know if it changes by hospital or healthcare facility. I don't have that knowledge in my head. I'm trying to remember if it was that detailed that it changes by hospital or medical group or, or type of facility. I'm sorry, that one I would have to look at the statute. Yeah.
No worries.
Yeah, sorry. I'm happy if people want to email me, if you guys want to provide my email, I'm happy, to answer questions that way too. If it's something where it looks like it's going to take a lot of legal research, I'll communicate about that. But I'm happy to look into, if it's an issue of just looking at the statute, I'm happy to field those type of questions after too.
Perfect. Thank you. Do employers need to do anything for SB 848 with the reproductive laws, such as designating the time off under the law as we normally would do with the CFRA? What are the immediate employer obligations to employees under the new law, if any? And I know that you touched on this, but maybe just a little summary would be great.
Yeah. What we've done for clients on this across the board has been included in the handbook, included in their employee handbook, and that applies to a lot of the things that we discussed today. Certainly the workplace violence prevention program, a lot of these things, not things like a rebuttable presumption for retaliation, certainly, or something like that, but a lot of them, it's an issue of putting it in the handbook. And the primary reason for that is you don't want a situation where an employee says, hey, I thought I could take this, or I didn't know I could take this leave, right? Like something happened, I had no idea I could take this leave. It is a requirement. It is something, it's obviously a tragic situation in certain cases. And so the companies are required to offer it. It's something that should be offered to employees. It's a revision to the handbook. Yeah.
Thank you so much. Regarding drug testing, are employers allowed to drug test after a work injury?
You are the standard. So again, my only modification or caveat to all the drug testing questions is depends to some degree on the industry, right? Again, if you're dealing with a trucking company and it's some kind of an incident and an accident, something like that, in most situations you're gonna have a greater ability to drug test than I would say, other employment places where you don't have quite the same safety issues. Like let's say it's a retail facility, but there's a serious slip and fall, right? Something like that. That would not entail automatic drug testing. That in that situation again is, do you have that reasonable suspicion, right? Like what led up to that slip and fall? If an employee was spending a lot of time in the back alley, other employees saw them come in, act excessively goofy, things. If there's enough facts that add up that indicate that something, that person, there's a objective, reasonable suspicion that person was under the influence, then yeah, you can certainly require drug testing. And what I would say too as well is, in that case,
accidents are a bit of a sensitive situation where you want to make sure they don't happen again. You want to make sure that the person that may have been injured or involved is protected. You know, you're probably going to have workers' comp issues involved with it as well. You want to make sure you're doing what you need to do to make the workplace safe. That may, in certain situations, entail drug testing. It's just you also have the competing balance of someone's privacy rights as it pertains to not being drug tested. Yeah, so it's a reasonable suspicion standard again.
Wonderful. One question regarding sick time: does it roll over or go away if not used? What's the most common approach?
It depends if it's you know, whether or not you can make sick leave go away. And I'm slowing down with a bit with this because it also brings up some of the PTO issues. So if it's a sick leave policy, you can make it go away at the end of the year if it's front loaded. If it's an accrual, again, you've got that cap issue to it, right? If somebody's accruing sick leave, they only get, you know, depending on the accrual method, they only get the full amount, you know, right near the end of the year. It can't be something that immediately goes away. My caveat to all of that, though, is I know we talked about making something. This is a downside to making something a PTO policy that covers sick. So if you have a situation where you've decided as a company you're not going to do the sick leave because you have PTO that covers all of that and provides even greater benefits or time perhaps, if you make something a PTO policy or a vacation policy, it's different. PTO policies, vacation policies, the rights you get under those, under the labor code, well, under the statute, sorry, under the cases interpreting the statutes, are vested wages. You can't get rid of those. Once somebody has PTO or vacation, you cannot have a use it or lose it policy. So a little bit complicated, but yeah. And in terms of what's most common, it really depends. It goes back a bit to the seasonal question. You know, if you have seasonal employees, I don't think you'd want to probably do a front-loaded policy. Depends on the company, but we've had a fair number of clients where we've talked it through, and for their situation, it has made sense to do a front-loaded policy for bookkeeping purposes, really, just to make it easy for that. And in that case, if you have a front-loaded policy, yeah, I would in most cases have that be something where it does not carry over from year to year, right? If you're giving somebody 5 days right off the bat, you know, and they've still got 4 at the end of the year, that can start to add up quite a bit over time. It depends on the industry. You know, it depends to some degree on the benefits that are provided to employees. There are some companies and some positions where they have very generous vacation and PTO policies, but I think in most cases, certainly with front loaded, it would be more common to see it go away at the end of the year.
Thank you so much. We do have a fair amount of questions regarding PTO. If you change your vacation policy to PTO, does it change the entire bank so that you have to use it like sick leave, or do you have to allow PTO/vacation leave with minimum notice?
I'm sorry, can you read that one more time? I just want to make sure I get it, because I think
absolutely. It's a big question. If you change your vacation policy to PTO, does it change the entire bank so that you have to use it like sick leave? Do you have to allow PTO/vacation leave with minimum notice?
Yeah, there is a decent amount to it. So it depends on how the company is doing things right now. Like, let's say you have here, I'll give you a better example. Maybe this helps answer it, because our firm did this. We used to have vacation and we used to have sick leave, and for various reasons, we just decided to combine it into an overall PTO policy. So I think that's maybe what's to some degree being asked. So what happened is, again, with vacation or PTO, you can't get rid of it, right? It has to be used, or when people are let go, it's paid out at that point in time. You can have requirements on how it's used and all, you know, and the notice that's required and all those kind of things. Certainly, it should be in a handbook or something in writing, but we had you can't get rid of, again, I just want to
clarify that, because that's a big issue. If people have banked vacation or PTO, can't be taken away, and you can't convert vacation or PTO to sick. It's different. It's a different right. It's a different benefit. So with us, what happened is we had vacation and sick, and we went to PTO effective as of a certain date. People just kept their vacation. I believe in what we had done for record keeping, and we had changed the name of it, vacation to PTO, right? As long as the vacation is being treated like PTO, as long as that doesn't, you're not taking it away from them, you're not changing the rights to use it. I think for administrative purposes, we had changed vacation to PTO just, as a line item. But we kept the sick leave that they had and used it as you would sick leave. So once that sick leave, and this was in our policy, once the sick leave, had been used up, going forward, the PTO that they were accruing covered everything. So that's kind of how we did it. And I know that may be a little different than, you'd have to work through the nuances of that for the company, but in general, that's how we did it and how it should function. Don't take away the vacation of the PTO. If you're getting rid of sick leave because you want your PTO policy to cover it, then don't get rid of the sick leave. Just allow it to run out and be used as it is. And then going forward, it requires a certain amount of, certainly from the changeover date, going forward, it probably complicates the bookkeeping to some degree, but for us over, after that got, folded in, it became a little bit easier. So I think that answered it.
Yes. Thank you. And any additional questions that we're not able to get to, we'll be able to reach out to you individually as well.
Yep.
This one is regarding the workplace violence. Does it need to include harassment claims, sexual harassment investigations that have been done in the past?
For the log, no. The log, there's nothing in the statute that requires, recording of past events. It's a going forward, this log needs to be kept. It needs to be made available as, as required. If there's past sexual harassment events, you don't have to I think largely it answers, the same way I did the previous question, which is if there were past incidents of sexual harassment, if they involved in any way, violence or a threat of violence or implied violence or something like that, it needs to be treated and addressed under the new law regarding workplace violence. If it's a purely, let's say you had a situation where it's purely a sexual harassment issue, there's no inference of any kind of violence, it's not going to apply under this specific workplace violence statute. It's not going to be the same thing. That being said, it's certainly something that should be documented. It's certainly something that should be investigated. There's already a requirement to do sexual harassment training. So, companies should be training on sexual harassment now, on workplace violence. The incidents should certainly be investigated. How they are recorded, how they are documented. Each company may have different procedures to it, but no requirement to go back to it. Again, my only input that I would say as well, though, is if you have a serious incidence of sexual harassment that was, let's say there's a lawsuit based on it, right? I think you're going to want to look at that in terms of, it might not play into the workplace violence statute at all, but if it does, certainly you'd want to address those concerns, considerations. The big thing for certainly workplace violence, harassment, discrimination, any of those things, the really hefty claims that you sometimes see against certain companies are ones where you have a pattern of things that keep happening. If you have a pattern where a company, let's say a company's gone through an age discrimination lawsuit and there's been a finding that there was discrimination and there's multiple incidents, when you have multiple incidents of one kind, it makes it very easy for a plaintiff's attorney to make the case that this company not only condones and tolerates these things, maybe it encourages them, So repeated incidents are something that should certainly be looked at with extra care.
Thank you, Derek. And it's with it being 10:45, folks, we're going to go ahead and wrap up the Q&A time. But again, for those of you that did ask questions that we didn't get to answer, we will gladly reach out to you after the webinar. We do have copies of all of the questions that you've asked today. Thank you, Derek. This has been amazing. This has been a very full class, and it's our last class of the year. We will be sending to you the plans for 2024. We've got a great set of classes that we'll be teaching, but we appreciate you all for taking time out of your schedules today to join us for our last Vendor U. As a reminder, this session has been recorded, and both the recording link and a copy of today's slide deck will be emailed to you following the webinar. If you have any questions that arise after the webinar, I'm sure you will, Derek will be copied on the email that I'll be sending out, so you'll have his contact information and he can help you moving forward, hopefully. But thank you again, and we hope you all have a wonderful day. Thank you, Derek.
Thank you, everybody. Thank you. Have a good day.